I'm Ira Maurer, founder of the Maurer Law Firm located in Fishkill, New York. Welcome to our website. At the Maurer Law Firm, we represent clients located in the northeast part of the United States who have become victims of a serious injury. It has always been my belief that every client deserves to be thoroughly educated about their injuries and the legal process. This video is intended to provide some helpful information about what impact the COVID-19 pandemic has had on personal injury litigation. The answer is roughly the same whether you're talking about federal court litigation or state court litigation. In many instances, pretrial procedures in civil litigation slowed down dramatically despite court oversight. In addition, pandemic safety protocols required the court systems to close down almost completely and stop scheduling all civil lawsuit trials for approximately 1 year. During that time, judges used virtual video conferencing and telephone conferencing to conduct pretrial conferences with attorneys, but cases were not receiving trial dates. The federal and state court systems worked hard to develop a means to conducting trials during the pandemic. Eventually, a limited number of trials were scheduled, but the trials were limited to being conducted in the largest courtrooms to provide for social distancing. Juries were split into two parts on opposite sides of the courtroom in federal courts. All participants, including judges, lawyers, jurors, and witnesses, have been required to wear face masks except where the witnesses and attorneys doing the questioning were placed in enclosures with adequate airflow and HEPA filters to permit them to speak without wearing a face mask. This system limited the number of trials that could take place to a handful of the largest courtrooms in each courthouse. The result is that an additional period of at least 1 year can now be tacked on to the normal waiting period for a trial to commence in federal and state courts. The courts have not yet announced what they intend to do about the huge backlog in cases waiting to go to trial. However, for plaintiffs and defendants who are interested in trying to resolve their lawsuits, sooner than later, the litigants have the ability to use alternative dispute resolution, or ADR for short, working with either a mediator or arbitrator who the litigants select or who is selected by the court system if they opt to work with a federal court mediator. That system is free to the litigants. The difference between a mediator and an arbitrator is that a mediator does not have the power to decide any of the issues and is there to only assist the parties in reaching a settlement agreement. An arbitrator is quite different because they're given full authority to decide all of the issues, and the arbitrator's decision cannot be appealed. Use of mediation or arbitration can significantly shorten the waiting time to bring a case to trial. Whether use of ADR is worthwhile in any given case depends upon a number of factors which must be considered by the parties and their attorneys. I hope you found this video helpful. For more information, please contact the Maurer Law Firm by calling 845-896-5295 or visit our website, maurerlaw.net. That's M-A-U-R-E-R law.net. At the Maurer Law Firm, we take your personal injuries and the impact they have on you and your families personally.